Good morning, guys. It's Mark Dawes here. It's Thursday the 3rd of March 2016, and I've just been looking through my Facebook feed this morning, and I've noticed an interesting post put up by Stephen Morrison, who runs Proactive Security Limited in Scotland. Now, Steve is a great trainer, and he's put an interesting post up which is to do with a Supreme Court ruling. And the ruling actually reinforces the fact that employers are legally vicariously liable for the actions of their employees. Now, what this means is that if an employee acts outside the scope of their employment or outside the scope of their training, historically in the past, in some cases, the employer could argue that that wasn't related to the employee's job, and therefore the employer is not liable. However, in this case, the Supreme Court ruling have held the judgment that although the member of staff acted outside of the nature of their employment per se, the company is still liable. And this is based on the back of another case which is called Hawley versus Lumina Leisure, and I'll come on to that in a second. If I just click over to the BBC report on this was in the news yesterday on the BBC webpage. They've actually reported on the same thing. And what they've done is actually commented and made some interesting points about this case, and I'll just scroll down and show you where these are. It actually says here that the Supreme Court has sent employers a wake-up call. It has broadened the law which holds employers vicariously liable for the acts of their employees who commit a crime whilst at work. Previously, an employer could argue that an employee was acting for entirely personal reasons. Lawyers call it being on a frolic of their own, if they committed a crime. It was only in cases where the employment itself involved a risk that a crime could be committed that employers had been held liable. So, for instance, in cases involving nightclub bouncers or wardens at residential care homes. This ruling makes it easier for customers of a business who are assaulted by staff or affected by staff who commit any unlawful act whilst on duty to hold the employer business liable. And also, as you can see there, likely to affect cases involving assault or harassment by co-workers at work. So this is quite an interesting case. It's a very, very interesting judgment, and I think we need to understand the severity of this. I mean, going back to the Lumina Leisure case, there was basically the Lumina Leisure, the nightclub, employed some doormen on a subcontracted basis. They brought in another company to run the doors. There was an altercation between a doorman and a member of the public. The member of the public was seriously assaulted and got head injuries and brain damage. And when the family of the injured person sued, they didn't sue the subcontracted company. They sued Lumina Leisure. Lumina Leisure argued the fact that they brought these people in to do this stuff and they should be trained, but the High Court ruled, basically the Court of Appeal ruled that they were deemed to be employees for the nature of the job that Lumina Leisure was asking them to do. And although this particular doorman had acted outside the scope of his role, it was so closely linked with what he was expected to do that the nightclub was liable. Now, this ruling has taken this even further because it says even if the employee is not directly linked, so in other words, a doorman expecting to eject people from a club or control people in a club is one thing. Hurting someone in the course of that duty outside the scope of that training is what the Lumina Leisure case was based on. In this case, this gentleman here acted way outside the scope of his training. He was basically a customer service attendant who followed someone out into a forecourt and assaulted them because he didn't agree with their particular views they held on a certain issue. And it had nothing to do with any aggression other than the fact that the aggression was, if you like, instigated by the employee itself. So what's the impact of this on us as training providers, or if you are a commissioner of training? Well, the impact's huge because it basically means that anything that a member of staff does, directly or indirectly related to employment, which has a negative effect on a service user, patient, pupil, member of the public, you, as the commissioning agency or the employer, are liable for. But let's look at some ramifications on this that I've come across recently in various discussions with organisations. As you may be aware from the blog post I put out, I had a conversation recently with someone who was a director of an organisation who said that they did not want to use restrictive techniques. And the reason for that was that Ofsted didn't like them and they could be basically sanctioned by Ofsted for using them, so they were going to take them out. The net effect of that is that staff will not be able to control some of the service users that are actually in that organisation's care. So that now creates a liability. So what if then the member of staff, then with less than adequate training, because the training that's going to be effective is taken out, or the techniques are going to be taken out, then relies on their own initiative and does something that they think they need to do, and ends up grabbing that person in the neck lock or pinning them to the floor, and that patient service user subsequently gets seriously injured or killed? Well, in this ruling, the employer is liable. And we've had other cases of this. One case I was involved in as an expert witness, where a member of staff actually told other colleagues that they were going to choke someone out. If someone, as they called it, kicked off tonight, they were going to choke them out. It's exactly what they did, and that person died, and the person went down for 8 years on that basis. But again, there is a liability for the company there. Now, one of the blog posts you've seen me put out recently is about the new soft restraint kit that Mark Williams has put out there. And again, I've had a conversation recently with an organisation who said, look, we'd love to have this kit because we've got a particular person that our staff need to control physically that they can't control. Hugely violent. They need to be controlled for their own safety. It has to be in the best interest of that patient to be controlled for their own safety using this kit. But the organisation's management will not allow us to have the kit because they seem it not conducive with what a healthcare organisation would do. So in other words, we do not want to be putting soft cuffs or belts on patients. Well, the net effect of that is, if that's what the organisation chooses not to do, that's the organisation decision. But then if staff in this case are getting hurt, then the organisation is liable. And if that went to court, based on this case and on the previous case precedent, the Luminar Leisure case, the employer hasn't got very solid ground to stand on. So this is a really, really important thing. And once again, Steve, thanks for bringing this to our attention. I'm glad you did so, mate, because it sparked off another thought process in my mind on this. And you've already seen the blog post I put out about the self-restraint kit. And if you're interested in training with Stevie Morrison, by the way, Stevie Morrison runs this company here called Proactive Security Limited up in Scotland. It's www.proactivesecurity.co. That's the website. Check Steve out. He obviously knows what he's talking about. It's great. If you're interested in knowing more about the soft restraint kit, then we're running a course on that on the 30th of March. Come down, have a look at that kit. It'll reduce your liability. No two ways about that stuff. And for those of you that have been calling in about the seminar this year, yes, we are running a seminar this year. We're running it sometime in June. We're just finalising dates now, and we're finalising the venue. And one of the things we'll be talking about on that seminar is vicarious liability. And we'll also be looking at the issue of audit trails and responsibility and accountability. As usual, we'll have Eric Baskin speaking at the seminar because he's dealt with a lot of these cases. In fact, he was the expert witness on the Luminar Leisure case. I'll be talking about some of the cases I've been involved with, and the aim of the seminar is to inform you and keep you up to date with the process. Because remember, it's not just getting training, it's getting the appropriate training that is also effective in controlling risk, and that's a really, really important factor. So Steve, once again, thanks for bringing this to my attention. I hope that's been useful to you. There's probably some links somewhere around this video if you want to click around there and find out some more, or drop me an email and get in touch. Thanks ever so much, guys.